Welcome to Do It for the Case Law for Tuesday, June 30th, 2026. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Today's docket features 89 federal appellate opinions across 10 circuits. Our team covers criminal justice matters including drug trafficking and firearms cases, civil rights litigation involving Section 1983 claims and employment disputes, Supreme Court and constitutional issues such as First Amendment religion cases and habeas corpus petitions, business and labor disputes alongside bankruptcy and intellectual property matters, and immigration appeals with a heavy focus on civil immigration reviews. Please subscribe to stay updated on federal appellate rulings. Do It for the Case Law is a news reporting service. We summarize and discuss federal appellate opinions. Nothing in this broadcast constitutes legal advice. Let's turn to James covering criminal justice.
Thanks, David. 23 criminal justice cases today across 8 circuits. The disposition mix includes 12 affirmances, 6 dismissals, 3 denials of motions for sentence reduction or new trial, 1 vacatur with remand, and 1 reversal. We begin in the 10th Circuit, where the court reversed a conviction on first-degree murder due to jury instruction error regarding imperfect self-defense in United States v. Lynn. In that same circuit, the court vacated a supervised release condition prohibiting possession of adult sexual images in United States v. Caraballo, finding the restriction violated federal statute and lacked a rational basis. The 10th Circuit also affirmed a denial of a motion to suppress evidence in United States v. Rodriguez after finding a post-op encounter was consensual. Moving to the 11th Circuit, the court affirmed convictions for coercion, enticement, and illegal image offenses in United States v. Williamson, ruling Yahoo acted as a private entity during its search. The 11th Circuit also affirmed a 120-month sentence in United States v. Ramos Cruz for conspiracy to bring a non-citizen to the United States and related firearm charges. In the 3rd Circuit, the court denied a motion for a new trial in United States v. Williams, holding that despite an erroneous colloquy on maximum penalties, his waiver of counsel remained knowing and voluntary. Over in the 4th Circuit, the court affirmed several convictions, including a fentanyl conspiracy in United States v. Costello, a felon in possession charge in United States v. Delaney, and a supervised release revocation in United States v. Harrison. The 4th Circuit also denied 3 motions for sentence reduction under Amendment 821 in United States v. Colagan-Bule, United States v. Rosales, and United States v. Locklear. Moving to the 5th Circuit, the court vacated part of a pretrial release order in United States v. Yuan because the government failed to perfect its appeal using the correct procedural vehicle. The 5th Circuit dismissed 3 appeals in United States v. Urdaneta Colina, United States v. Guajardo, and United States v. Ramirez after Anders' briefs found no non-frivolous issues. It also granted summary affirmance for illegal reentry convictions in United States v. Salas Romero, United States v. Beltran Nino, and United States v. Zertuche Reyna, noting that challenges to sentencing enhancements are foreclosed by the Supreme Court's decision in Almendarez-Torres. In the 6th Circuit, the court affirmed a 330-month sentence in United States v. Brown, finding he waived his right to be present at resentencing. The 7th Circuit affirmed a felon in possession conviction in United States v. Banks, upholding the denial of a motion to suppress. Finally, the 8th Circuit affirmed wire fraud convictions in United States v. Crump and a methamphetamine distribution conviction in United States v. Pineda, rejecting arguments on evidence sufficiency and duress instructions. Back to you, David.
Thanks, James. Let's turn to Aisha for the Civil Rights Roundup.
Thanks, David. I have 17 cases covering the 1st, 4th, 5th, 6th, 9th, 10th, and 11th circuits. The disposition roll-up includes 7 affirmances, 5 dismissals for lack of jurisdiction or procedural defects, 2 remands, 1 vacatur and remand, and 2 denials on habeas petitions. Let's start with the movements that changed the lower court's result. In the 1st Circuit, the court vacated summary judgment in a political employment dispute involving Lopez Collazo Ortiz and others against Ruiz Feliciano and city officials, holding that refusing to reappoint a former employee is an adverse action and that trust classification alone cannot justify a political requirement without a fact-specific inquiry. Moving to the 10th Circuit, the court reversed the dismissal of Utah Political Watch against Musselman regarding media credentials, finding that excluding independent journalists from capital areas based on viewpoint violates the First Amendment in a limited public forum. In the 6th Circuit, the court affirmed the denial of qualified immunity for officers Pitsley and Rennie, who participated in a private eviction, determining the plaintiff had a valid possessory interest in the property under Ohio trust law. Now for the remaining outcomes by circuit. The 4th Circuit dismissed 3 appeals, 1 Curtis Green case for lack of finality, 1 Willie Doremus civil rights claim for failure to state a cause of action, and 1 Takara Puller appeal for an untimely notice of appeal filed in April after the January judgment deadline. The Fifth Circuit affirmed 2 prosecutorial immunity dismissals against assistant district attorneys in cases involving suborned perjury, plus a summary affirmance dismissing a wrongful death claim against Bossier City officials due to lack of evidence regarding suicide screening duties. They also dismissed a Victoria County appeal for an untimely notice of appeal. The Ninth Circuit affirmed 3 cases, ExxonMobil won on a contract dispute over the Montana Prompt Payment Act, Seattle Children's Hospital kept its False Claims Act retaliation dismissal but lost the prejudice ruling requiring refiling, and a pro se prisoner Hunter lost due to failure to exhaust administrative remedies under the Prison Litigation Reform Act. Finally, in the 11th Circuit, the court affirmed excessive force findings against Officer Grubbs for tasing an unarmed suspect on a steep embankment while dismissing a shotgun pleading by Jacob Barry Alston in a Section 1983 suit against Florida officials. Back to you, David.
Thanks, Aisha. Michael has the constitutional law and habeas corpus roundup.
Thanks, David. Michael Reeves here with 17 cases from the 1st, 9th, and 4th Circuits. The disposition roll-up includes 1 reversal, 2 affirmances, and 14 dismissals or denials. Starting in the 10th Circuit, the court reversed the district court's denial of a habeas petition for Rigoberto Quiros, holding that the mandatory detention statute applies only to non-citizens at ports of entry, not those arrested within the interior, meaning he is entitled to a bond hearing. Moving to the 4th Circuit, the court affirmed 2 prisoner litigation cases. Bruce Buckner's PLRA claim was rejected after reviewing the magistrate's recommendation, and Renesha Green McNeil's challenge to her sentence execution failed due to unexhausted administrative remedies. The majority of this circuit's docket involved dismissals for lack of a certificate of appealability or untimely filings. David Hill and Lester Cadell Little had their appeals dismissed because they missed the 30-day deadline to file notices of appeal. Antoine Miles, Jamel Robinson, Mezeron Taylor, Colin Lafreniere, Edward Duggar, Kevin Lydon, and Russell Murray all failed to make the substantial showing required for a certificate of appealability in their Section 2255 motions. Additionally, Hunter Potts was dismissed for failing to show debatable constitutional claims. Robert Decker's mandamus petition was denied due to no undue delay by the district court, and Jeremy Fontenez's petition was barred for failure to exhaust administrative remedies. I'm Michael Reeves at the Supreme Court.
Thanks, Michael. Maria has the business and civil news from across the circuits.
Thanks, David. 15 cases in this block. 10 were affirmed or dismissed, 2 were reversed or vacated, 2 were remanded, and 1 was a split outcome. Starting with the Fifth Circuit, the court reversed the denial of Apple's request for a protective order limiting disclosure of agreements to outside counsel only, finding the district court erred by relying on foreign law before German or Indian courts issued mandates. In another Fifth Circuit case, the court vacated a Department of Health and Human Services decision imposing a $19,192 civil penalty against Texas Tobacco Barn, ruling that the Seventh Amendment right to a jury trial applied because the penalty was a legal remedy at common law. Moving to the Sixth Circuit, the court remanded state environmental claims involving PFAS contamination back to state court after affirming the severance from third-party claims against AFFF manufacturers. In the Ninth Circuit, the court vacated and remanded a dismissal for lack of personal jurisdiction against Phoenix International Limited, holding that the company's substantial revenue from California consumers satisfied the purposeful direction standard. The same circuit also granted a petition in part and remanded an immigration case involving Guo v. Blanche, finding the Board of Immigration Appeals erred by failing to apply precedent on past persecution regarding police beatings and religious restrictions.
Additionally, the Ninth Circuit granted and denied parts of a petition for Rojas Chavarria et al. Versus Blanche, remanding for further proceedings where the burden shifts to the government to rebut the presumption of well-founded fear based on political opinion. The court also dismissed an appeal in Diaz de Leon versus Solar Mosaic due to unresolved mootness issues arising from bankruptcy. Routine outcomes included affirmances in the Fourth Circuit dismissing a motion to reopen a case after 28 days and denying standing for a plaintiff against Walden University, as well as affirming a stay of a civil rights action due to a bankruptcy injunction. The Ninth Circuit also affirmed summary judgment for defendants in a labor union dispute under the Labor Management Reporting and Act. Finally, the Fourth Circuit dismissed a habeas petition for lack of jurisdiction, and the Eighth Circuit dismissed an appeal regarding arbitration consolidation for being non-final and untimely. Back to you, David.
Thanks, Maria. Let's turn to Raj, covering immigration and government.
Thanks, David. We have 17 cases today from the immigration docket. The disposition roll-up shows 16 denials and 1 dismissal. There were no reversals, vacators, or remands in this block. First, over in the 11th Circuit, the court dismissed a petition by Pineda Marquez. The court held that because the petitioner failed to challenge independent alternative grounds supporting the judgment, specifically the determination that asylum applications were untimely, he is deemed to have abandoned those challenges. Now moving to the Fifth Circuit, the court denied Delmi Carrasco Aguilar's petition for review. The court found substantial evidence supported the Board of Immigration Appeals' conclusion that she failed to establish past persecution, distinguishing her testimony regarding armed robberies from a sustained campaign of intimidation. Over in the Ninth Circuit, we have 15 cases where the court denied or affirmed denials. In Alfaro Cruz, the court held that substantial evidence supported the finding that the petitioner was a victim of a personal dispute rather than persecution based on membership in a particular social group. The Verdugo-Castillo panel found petitioners forfeited their challenge to the government's ability to protect them from gang violence and found the record insufficient for Convention Against Torture relief. In Diego, the court affirmed the denial of asylum, holding that the petitioner provided only speculative testimony regarding the futility of reporting her ex-partner. Efrain Gonzalez Francisco was denied because the court found gang attacks were motivated by financial gain rather than race or indigenous status. Maria Escalante Escobar's petition was denied as the assault was deemed a random act of violence without a protected ground nexus. G.A. Chen and Yaxian Chen faced an adverse credibility finding upheld on substantial evidence due to contradictions regarding religious conversion and forced abortion. Juan Medellin failed on multiple grounds including a jurisdictional challenge under Pereira v. Sessions which the court rejected, and failure to exhaust asylum claims. Julio Lopez Morales was denied because the court found gang violence motivated by theft rather than land ownership membership. The Garcia Utuk brothers forfeited their claim regarding government inability to control forces and failed the Convention Against Torture likelihood standard. Pavel Kuzin's group-based theories of future persecution were rejected for failure to raise them before the immigration judge. Luis Perez faced an adverse credibility finding due to inconsistencies regarding the source of threats and employment status. Mark Mendoza's motion for reconsideration was properly denied as he raised due process claims too late. Ben Taftsarche could not argue that the spouse statute includes putative spouses because he failed to present this specific legal claim to the board. Walid Majdoub's second motion to reopen was denied as untimely and number barred. Finally, Yangying Zhang's petition was denied due to significant inconsistencies in her testimony across different stages of proceedings. Back to you, David.
That wraps up our coverage for Tuesday, June 30th, 2026. A massive thanks to James Taylor, Aisha Johnson, Michael Reeves, Maria Santos, and Raj Patel for their reporting today. The day's docket saw 53 cases resolved with 37 affirmances, 11 other dispositions, and 41 dismissals. While most appeals were affirmed or dismissed on procedural grounds, the significant outcomes of the day included several reversals, vacated decisions, and remands that will shape future litigation. A number of cases were dismissed without reaching the merits. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Do It for the Case Law is a news reporting service. We summarize and discuss published federal appellate opinions. Nothing in this broadcast constitutes legal advice. We are not lawyers. If you need legal counsel, consult a licensed attorney in your jurisdiction. Please subscribe and follow us for daily updates.